How you doing, family? This video is about standing. So there's two types of standing: civil and criminal. First, I'm gonna talk about the criminal one, and then the civil. Criminal. When you challenge standing, it's not really challenging; it's invoking standing. I'm gonna give you an example. You're in a criminal case, you're the defendant. You're saying that that law that they're using against you is unconstitutional. So in order for you to challenge it like on constitutional grounds, you have to create standing. Or else they're gonna say, "Oh well, if it doesn't affect his constitutional rights, you can't challenge. You have no standing." So, for example, people with you know how people go to court to challenge gun possessions or failure to obtain licenses. Some people usually cop out straight to the gun charge. You get like before it used to be a city year, which is like 8 months. Now it's a 1 to 3. So you could say that, oh, listen, illegal possession of a weapon. Your lawyers, they're gonna shit on you. They're not really that good because they do this to the court. No disrespect to any lawyers or attorneys. If anything, look for constitutional advocates. It's like a lawyer, but it's actually they can fight and defend you. Now you're gonna say, well, Your Honor, that law is unconstitutional. It violates my Second Amendment. Boom. You invoke your standing. You're gonna say that it is affecting your constitutional rights. Which rights? The Second Amendment. Or if you're traveling, which people would like to travel in their cars, private automobiles, um, word for the wise, every word has a different meaning, okay? So the word driver is somebody that gets paid. But to all people, mostly everyone, they saying driving is just being behind the wheel, the steering wheel. That's not true. That means that you have to get paid. So you gotta do your due diligence. There's some cases I don't have them in the top of my head, but so you say you got arrested for expired license or failure to register or failure to insure. You're gonna say that it violates your First Amendment. Boom, you created standing. Now, if you don't assert your constitutional rights as a defendant, you have no standing. So you can say, "Oh, well, I don't need a license, or I got the right to travel and all that," but you got to use the word constitution and the connected to the constitutional defense. Once you challenge anything and you can't name a constitutional right that's being violated, you have no standing. They're gonna continue. They're gonna proceed. And they're not even gonna. You're not gonna have a chance to create a record. That's criminal. I could elaborate more if people, comment or request further information. I could do that. Now, civil usually depends. If you're the plaintiff, you automatically, in a way, got standing. Well, no, you automatically got jurisdiction. You give it to them because you're the plaintiff. But standing as a plaintiff in civil court, you have to do the same thing as you as a defendant in a criminal court. You have to allege or invoke a right that was violated. If you can't articulate your complaint, claim or complaint, your claim into a constitutional argument and the other side challenges your standing, meaning that you haven't been injured, there's injuries, but some injuries are not constitutional injuries. You most likely will lose. The judge is gonna throw it out. So you gotta connect it to some type of injury. I'm gonna give you an example. I'm traveling in my private automobile, right? Let's say it's not insured, I got no insurance, I don't have anything on it, right? And they took my car and I was in court and I won. For some reason, somehow, some way, the charges were dismissed. So now I'm suing because they took my car, but I didn't get it back. So you're gonna invoke your standing and you're going to defeat the Iqbal standard. The Iqbal standard is conclusory, meaning that you jump straight to the end, but not the beginning. So you would say, listen, the officer has he took a constitutional oath to uphold the Constitution, and he owed me a duty by not violating my rights. And he breached that duty when he took my property without due process. He didn't give me a receipt. He didn't give me a court date for the car. He only gave me um, a summons to appear in court. So that's the Iqbal standard. This is how you go into court. This is your standing. You say, this is a constitutional right, and this is how initiated. Even if it's like other companies, you gotta say that there was a duty and the duty was breached. That's the Iqbal standard. You can't just jump to like my car was taken. They want to hear the words that they had some type of duty and they breached that duty, and by breaching that duty, it caused you injury. If you don't say these words the way I just said it, you just say they violated my due process, they violated my equal protections of the law, they took my property without a court date. It's not gonna be the same thing. You have to say they owed you a duty. So that's standing as a plaintiff. Now, sometimes when you appeal a criminal case, you become a petitioner, which is similar to a plaintiff, but you're appealing a criminal case, so you become the petitioner, and you're gonna need that type of standing. If you can't create that same standing, then they're gonna dismiss your case. You're gonna lose your appeal. So now, if you're a defendant in a civil case, and for instance, let's assume it's some type of government agency, not an individual. 10 out of 10 times you're gonna win because you're gonna challenge standing. Now in New York, you have to challenge standing within the first 30 days or your first answer. If you don't challenge standing, it's waived. You lost it. You don't have it. You can't bring it up later, and they messed up like that. So you as a plaintiff, no, not as a respondent. In a civil case, you're a respondent. You're not a defendant. Sometimes they'll call you a defendant, but usually you're a respondent to a civil case. So say you got a car, or the government, or non-government, but it's an agency. You took out a car, and you filed some type of paperwork where you try to get the credit consumer law, and then within the 3 days or even after you failed to pay, you canceled the contract or you got voided, and they're gonna say, we're gonna come repo the car, and you tell them, listen, I can't afford to pay. Do you want me to bring the car back and maybe we could talk something out? They're gonna be like, no, if we take the car back, we're gonna have to sell it, and then whatever doesn't cover, you have to pay us. So you're gonna say no. Do you trying to make amends with them by trying to give back the car in a way where you're returning it and they can resell it? But when they after you breach the contract, they don't take the car like that. They want to auction it and sell it, which is totally different because it's no longer them, but it is them. But the process is different, so it changes everything. So you're gonna challenge standing, and when you challenge standing, you gotta use the case. There's two type of cases. One is for federal and one is for state courts. So back in the days previous to 2016, you couldn't challenge standing unless it went all the way to the Supreme Court, from my understanding, to federal courts, not Supreme Court, federal court. So now the court case that you want to use to challenge standing, it's Spokeo Ink V Robings. It's a 2016 case. You put Spokeo Ink V Robings. So now what the court is saying, that Congress cannot waive this. They have to respect the Constitution. And in the opinion in this court case, the court said that Article 3 standing in the federal courts applies to the states, which is called statutory standing. So when you use this case, it's the same case as the federal case, which says that the person suing you themselves have to have an injury. So remember what I told you. If you can't connect the injury, then they're gonna throw your case, right? So here, the people that sold you the car made you a contract that if you failed to pay, these other people got the right to sue you. So now when you go to the court and you defend, you say, Your Honor, I like to challenge standing under Spokeo Ink V Robings, saying that the person suing me is not the one that suffered the injury. There's no connection. Now, he might be a worker. He might work for the company. He might be the one enforcing the contract, but they have no standing. They have no standing because regardless of you winning or losing your case, it doesn't affect them in any way because they're still going to work for that company. They're still going to get paid. They're still going to do what they got to do. Now, they may get a bonus, but that's bonus is bonus. It's not a regular pay. It's not you get what I'm saying? It's not a direct connection. There's no injury. He didn't give you nothing. He's just representing the one that's injured. And now the one that is injured, it's a company. It's a corporation. It's not a human being. So you can't say these things like this. So the way you saying is I challenge standing. They have no standing. Your Honor, the person bringing the suit is not the one that did the contract. Now, when you get sued, they try to enforce Uniform Commercial Code on you in a regular court. If you read the document, it says this contract is subject to the Uniform Commercial Code, and then they put a lien on you. And the lien is not even a real fucking lien. Excuse my language. It's not even a real lien. You have to search a lien. In order for you to understand what a lien is, it has to name you exactly for who you are. Your first name, your last name. If any letter changes, it's called seriously misleading. And then that's it. They lose. They lose. You could add one dot to my name and you're going to lose. You could change one letter on my name to a capital letter or a smaller letter. And if it's not the same one in the contract, it's considered seriously misleading. Because, for example, my name is ABC. And that person right there is ABCD or ABC1 or ABC2 or ABC dot. It's not one and the same. It's not. It's considered seriously misleading. So you got to check the lien they put on you. And now the case that's coming against you is going to say Nissan Motor Inc. And then when they're suing you, it says Nissan Motor Incorporation. It's not the same people that's suing you to the one that did the contract. It's seriously misleading. Now that's fraud. That's not right. According to the Uniform Commercial Code, it's seriously misleading, and therefore the contract is void. Now I have a case. I can't remember it. I could look it up, but not right now because I can't pause and edit my videos like that. I'm just getting to the video thing. So when I get to it, I'll edit it. I'll try to add it in the subscription later. But I know you challenge standing. You're going to tell him, Your Honor, the plaintiff has no standing. He hasn't or she hasn't suffered an injury. In fact, they didn't lend me no car. They didn't give me a loan. They didn't give me any of that. The company probably did, but not them. And then there's no connection. There's no injury. In fact, and that's how you challenge standing. And you can win. The court is going to tell you, I'm sorry, but they don't say it like this, but this is what they're saying. So and so, before we answer your constitutional challenge of standing, it came to our attention that the plaintiff's claim is not sufficient on its face, and they're going to dismiss it because they don't want to do anything in regards to constitutional stuff. They try to avoid it. Now, there's lawyers out here that when they go to schools, they teach them how to enforce statute. So you fighting the prosecutor statute, everything's statutes. Now, when the statutes collide, that's when they tell you go to primary law, which is Constitution. To me, that's silly. Go to straight Constitution. You know what I'm saying? Straight Constitution. They want to use this and they're going to tell you switch this and switch that and all that. You're going to be like, no. Article 6, paragraph 2 says that the Constitution is the law of the land. And under the Supreme Court decision of Spokeo Ink V, Robings, it says that the plaintiff needs to allege an injury in fact. He can't say that it's going to hurt him in the future, because if I can't say that I'm going to get hurt in the future and they can't sustain my case, they're not going to sustain their case. So that's that. You know what I'm saying? Challenge standing. Spokeo Ink V, Robings. Your Honor, the plaintiff has no injury in fact. The injury in fact, meaning that the plaintiff has to suffer the injury themselves. They didn't suffer anything because they just put in an affidavit that a call was given to you or something was provided to you by a certain company, and that company is not this person. Because then you invoke the Sixth Amendment and you say, you know, I got the right to face my accuser. And then if they allow the accuser, then you got to make your own subpoenas. You got to create your own subpoenas, because if you don't create your own subpoenas, then you can't question them to an extent. You can only question them in regards to what they have in their complaint. You can't bring other stuff in. But if you subpoena them yourself, you can ask them whatever you want. I learned that from experience. So you subpoena the witness, even though he's the one coming against you. You want to subpoena him or her, and you say, Your Honor, I want to subpoena the complainant. When you subpoena the complainant, you're gonna be like, what is your name, so, but you're bringing a claim under this and that, and you're not that, right? No, I just work for the company, Your Honor. I object. There's no standing. I motion to dismissal with prejudice for failure to state a cause of action for which relief may be granted, meaning that there's no remedy because there's no tort, there's no case, and that's how you got to do that. um Comment, subscribe, ask questions. If you could donate. And this will give me more opportunity to create more videos in order to help you. Thank you.